Chairman. Thank you, members of the committee. I'm going to talk very fast. I'm going to ask for about 5 minutes. Please ask me the hard questions. Christopher Sevier went to Vanderbilt undergrad, Vanderbilt Law School, was a Judge Advocate General in the United States military, an Assistant United States Attorney, constitutional federal litigator. I've litigated against the tech companies involving matters concerning Section 230. Very complex area of the law, involves a lot of First Amendment issues. There are 29, so quick background. There's about 29 states carrying this bill. Democrats are the prime sponsors in many states. It's a bipartisan issue. There's a lot of Democrats who are being censored if they're not woke enough by the major social media websites. Bottom line is that I'm going to hit 4 quick points. Okay, number one, the ultimate question is, what's the best solution to the ongoing problem of social media censorship? Is it an executive order by the president? Is it Senator Josh Hawley's attempts to repeal Section 230 of the Communications Decency Act? Or is it Representative Coleman's House Bill 482? And the answer is it's House Bill 482 because it was written deliberately to fall within what's called Sections 230 state law exemption. It's subsection E, paragraph 3. Basically, what that means is the states, basically the first question is, okay, well, what is Section 230? Okay, it's an immunity defense as part of the Communications Decency Act. Congress passed the Communications Decency Act in the 1990s to protect decent speech. It did not pass it to enable deceptive trade practices, okay? Basically, the bottom line is that Section 230 creates an immunity defense for internet intermediaries. So what does that mean in English? Because I'm like Representative Coleman, I'm a simple guy ultimately. And so what that means really is that if someone posts a defamatory comment on YouTube, the person who is defamed can sue the person who defamed them. But if they named YouTube in that cause of action, then YouTube can file what's called a motion to dismiss pursuant to 12b-6, for example, where they can invoke Section 230 immunity defense, and the courts would say, yes, that's a good use of Section 230. YouTube just provided the platform. And so they could be dismissed from that case. So what's been happening now is it is a breach of contract issue, but it's called an adhesion contract, which I'll explain later. But basically, the bottom line is that what's happening is they're censoring users for their religious or political beliefs. They're moving these standards all the time. They're moving the goalposts, which is per se bad faith and unfair dealing. And when they get sued in court right now, what they do is they go, Your Honor, Google, for example, Facebook, for example, say, Your Honor, we're merely editorializing, and therefore we'd like to invoke Section 230 of the Communications Decency Act. And generally speaking, the courts are going, I think you're being as a speaker and a publisher, but I'm going to let you go. And they've been kind of given the nod, would be our impression as federal litigators to work in these areas. That they're basically, the courts are kind of suggesting, well, if the states would pass a state law that would fall within the exemption, then you might not be able to invoke that defense. Well, that's exactly what's before you guys right now. This before 29 other states. Passed out of committee today in South Dakota. Passed out of the House floor today in North Dakota, for example. It's being amended to reflect the same language that he has. And basically, the bottom line is that Section 230, there's a state law exemption that allows the states to pass a law to stop the ongoing abuses that are taking place. And that's exactly what this bill does. It parallels the spirit of Section 230. So that's point number one. That is why this is the best solution to this problem, because otherwise other bills that get filed, they will invoke that section and they will likely win. That's number one. Point two is, what does the bill say? That's the question. The bill says that going forward in this state, if a social media website censors a user for religious or political reasons, and if that social media website has more than 75 million subscribers and was never, this is important, was never affiliated from their inception with a religious or political program, then the censored user would have standing to bring a private right of action that accords with Section 230 state law exemption through this statute, where they could seek, number one, up to $75,000 in statutory damages, attorney's fees, costs, and actual damages. Now, 75,000 is a magic number because it's called what's called the jurisdictional minimum, which a litigant could sue in federal district court under what's called diversity jurisdiction. Very powerful because this bill would allow a choice in venue. The injured party could sue, or the attorney general could sue in state court or federal court. Either way, there's a thing called the American rule that says a party can't seek attorney's fees unless there's a statute that allows it. So this statute permits for the injured individual to seek to recover attorney's fees, and what that will do is it will incentivize local lawyers to represent your constituents when they're being censored, whether they be Republican or Democrat or whatever, because their speech happens to offend the delicate sensibilities of the employees who work at Facebook, Twitter, and YouTube. Okay, another point, point 3, is that contract law is a state law issue. You guys, the state legislatures, have paramount jurisdiction over contracts. When a person in this state signs up to use Facebook, Twitter, or YouTube, they are entering into a contract. When Facebook, Twitter, and YouTube engages in a bait and switch, they've marketed themselves as being free, fair, and open to all ideas, and that's what they've done. That's why they have billions of subscribers, only to turn around and censor a user because of their religious and political worldview, whether that be for the right or the left, either way. That is an existing form of breach of contract, bad faith, unfair dealing, unjust enrichment, false advertising. It's called deceptive trade practice. This is a consumer protection bill. Okay, another point, I guess 4, and that would be the underlying constitutional legal basis for this bill is the First Amendment of the United States Constitution, as well as Article 1, Section 5, 6, and 7 of the Missouri Constitution. The First Amendment is very confusing, very complex area of the law. First Amendment only applies to the state. It restricts the state normally, or the federal government as well, restricts the government from encroaching on free, protected forms of speech. It doesn't apply to private actors. But let me say this, and basically the opponents of this bill always get up and they say, well, we just have this weird feeling that this violates the First Amendment in some general, vague way, but they never can defend that. The First Amendment is also a trampoline in that it allows the states to protect forms of protected speech as well. So it can be used as kind of a catalyst as well. And this is important. Deceptive trade practice, breach of contracts are not protected forms of speech. Okay, the state has a compelling interest. It's called a narrowly tailored compelling state interest to pass this bill to protect your citizens so they can express their religious and political worldviews and what amounts to the modern day digital public square. And that's what these guys have created. I mean, Attorney General Barr called it the greatest bait and switch of all time, and I think that's a pretty big underestimation. Basically, what they've done is they've marketed themselves as being free, fair, and open to all public ideas, only to turn around and then censor people after they induced people to sign up. Now, you talk about contract law. Well, they have what's called a contract of adhesion. That means courts don't really expect anyone to read it. The representative said he didn't read it. You know why? Because no one reads those contracts. There's no real expectation to read there's not 10 people who've signed up and they hired lawyers to read the contracts. So the courts kind of look at that as like, well, we'll consider that, but really we're going to look at how they've marketed themselves. And they marketed themselves as being free, fair, open to the public, and open to all ideas. If a social media website was created today after this bill passed and says we are a Wiccan website, that's what we are. We believe in Wicca. And if you didn't, we're affiliated with, let's say, the Green Party, all right? And you post something up there that's adverse to the Green Party, they can delete you. They're not subject to this bill. If you post something that would be inconsistent with the Wicca religion, for example, they can delete you, be consistent with this bill. Point number 4, the exemptions that are built into the bill are predicated on common sense. They parallel the spirit of Section 230. So, for example, basically they can censor if the speech is pornographic in nature, which is not protected free speech, number 1. Number 2, they can censor if it's a false account. That means false impersonation, as Mr. Chairman kind of identified. It deals with bad faith action, not an anonymous account. There's a difference with a distinction. They can censor if it's a call to immediate acts of violence, because that would, like one of the representatives indicated, would be a form of unprotected speech, because going in and shouting fire in a building that's not protected, for example. And so it basically carves out and mirrors the Section 230. So that's a very quick overview. I would ask that if you have hard questions, please direct those at me, because I've been beat up in federal court over these issues, so I can maybe give some answers back. But with that, I'll stop. Thank you for letting me go that long, Mr. Chairman.
All right. Thank you for that testimony. I do have a few questions.
Yes, sir.
So to begin with, I'm a little confused over how this is a contractual or a regulation of a contractual agreement. This appears to be a fine for behavior, like a cause for action for specific behavior. Could you walk through how this is actually a regulation of contract?
So it is a civil. In the simplest terms, this bill creates a cause of action under what's deceptive trade practice law. There are contracts involved in this situation.
But it preempts contracts. I mean, you could not contract away under this language your right to religious speech, for example. You couldn't. A social media company couldn't say that as a requirement of having an account with our platform in the adhesion contract that you mentioned. You cannot discuss religion.
It could if it from the so Facebook, for example. Let's say Facebook from its inception. There's some friends of ours called Warriors for Christ. They started a Christian social media website, and basically, they market themselves as we're a Christian. We have the Christian worldview. If you post things that are inconsistent with this, we'll delete you. Okay, first of all, they don't have more than 75 million subscribers. Neither does Parler, by the way. But if you market yourself from the inception is being free, from being free, fair, and open to the public, instead of saying no, we have this narrow worldview that we're advocating. This is a difference with a distinction. So there's a lot of principles at play in this bill.
But typically, with a contract, you have the ability to change it and update it as time goes on. So if I contract initially with your company for a year, let's say that this is the rules of conduct that we're going to engage under, that can change later. So, I mean, this would seem to lock in, like, the original purpose, raison d'etre of the company for all eternity.
Well, in an instant case, entering into a contract where the terms continue to shift and move, that's not really a contract. That's per se bad faith. That is per se unfair dealing. If you keep changing the terms of the agreement, even if you say from the beginning, I'm signing some adhesion contract where we're going to keep changing the terms of the agreement, the courts aren't going to respect that.
How does this work in like a financial services context? Like I had a credit card. Those typically have contracts of adhesion. And those terms change over time. The interest rates may change, like the amount that I can borrow may change. How is that handled? Well,
in the instant case here with this bill, there's a major difference with the distinction. It's not apples to apples, because in this case here, you're dealing with a modern-day digital public square. As one representative indicated, I mean, some courts are going as far as to say you have a fundamental constitutional right to have access to social media websites. And we're not saying that in this bill. But we're saying that they have created a digital public square, and they've done it through fraud. And as the representative said, Gentleman Coleman said, his constituents who've been coming to him, they can't fight back. Because if they sue right now for this kind of bad faith breach of contract, there's a lot of representatives, there's a lot of senators who've paid a lot of money to have ads promoted, and they've had their accounts deleted right before an election. And there's tons of pastors and different groups that have been censored after they've spent an enormous amount of energy into that. So, respectfully speaking, in terms of contract of adhesion with credit cards, there's just big distinctions with differences in the instant case here because of all of the factors taken in the aggregate. And the courts look at that kind of stuff when you're dealing with contracts, because generally they want to enforce contracts. I mean, generally they go, look, mutual assent, meeting the minds, all that stuff. But in the instant case here, I mean, there's no expectation for the major social media websites, Google, Twitter, Facebook, for people to go hire lawyers and read the terms of services. But their shifting of the moving of the goalpost, I would say, is bad faith, unfair dealing.
Well, it does seem to me that there should be some kind of guardrails around the ability of the contracts to change and maybe inflict material harm on someone that's engaged in sponsored content or other kinds of investments into their platform.
Yes, sir.
But I'm not entirely comfortable with the idea that the contract once set should be unchanging eternally. That seems like a very different concept than we're used to dealing with.
Well, in the instant case here, what this bill is doing, what you guys are doing, is you're saying we're going to hold these social media websites that fall in this very narrow category, 75 million subscribers that market themselves being free, fair, and open to all ideas, to higher standards of care. You can do that. You can put certain restrictions on them, and especially if they're engaging in existing forms of bad faith, breach of contract, unfair dealing. I mean, I'm with you. I'm not for changing the rules, but this is a very special circumstance. It's very injurious to the people who live here and to our democracy in general. I mean, it's definitely with, I'm a Christian. I have my own worldview, but I definitely want to hear objections and criticism of my worldview. And so there's just a lot of difference with the distinction. It's a very special case. I mean, this is why such great pains have been gone through to try to figure out what do we do? Did we repeal Section 230 like Senator Hawley wants to do? Do we do that? Well, That would be a lot of secondary harmful effects from that. Do we do nothing?
Well,
I mean, that would be one option, and right now it's creating a lot of problems if we do nothing. So,
unfortunately, one of those seems to be a federal issue, and so we don't have to wrestle with that in the immediate case here.
But this bill, federal law preempts state law, and this bill is written to fall within the exemption, so you don't have to repeal it. And the judges we've been before and so forth, I think they're indicating that that's what they want to see. That's just based on that's speculation.
The other question I had was regarding the hate speech definition. It uses the term arbitrary standards.
Yes, sir.
So does that suggest then that if the standards aren't arbitrary, if they're the result of some kind of deliberative process, that they would be acceptable?
So in the instant case, what the bill's referring to when it's saying hate speech, the section is basically, it defines hate speech. Basically, whatever offends the delicate sensibilities of the employees who happen to work there at that day. Okay,
well, right, but that's fine as a definition. Yep. But what if a social media company set up a review board, and that board went through a process and determined that it's not based on the arbitrary sensibilities of any individual in the company; it's based on the deliberative process of this entity that is created within the company to review these.
That's fair enough. So if they said, let's say, I don't know, what's a group that favors hate speech? Let's say that's the LGBTQ community. Let's say they use a hate speech term a lot. It's a term of art used in that secular humanist group. Okay.
Or let's say they use just some kind of third-party entity like the ADL or something that has these kinds of.
Well, if they market themselves as like, we have these certain values and we believe that these offend our worldview, and they do that from the beginning, and you have warning upfront notice of that, then that's the difference with the distinction. But to now just say, well, we're going to come up with hate speech and we're going to keep changing that definition. Those websites that have reached critical mass, and that's a magic word we use in court, because they've reached critical mass, there's a different standard they're being held to, because they've reached that through fraud. By basically saying, oh, we're welcome to all ideas, only to then turn around and say, no, we feel like arbitrarily today that constitutes hate speech because really we don't like your religious or political view. That's basically what that means in reality. And so we're saying if they delete someone and say, well, we formed a committee, we had a review board, and the 5 of us who live in Los Angeles feel that it violates our feelings here of what we believe in LA, let's say, that can't, if they get sued pursuant to this statute in court, whether it be state court or federal court, they couldn't invoke that as a defense. And that's the only applicability of hate speech to this bill in terms of the 4 corners of the bill. So,
all right, thank you for those answers. Any other questions from the committee for this witness? Yes, Representative Rogers, please proceed.
So, I've got a bunch of questions. I'll try to keep it brief. But
go for them.
I believe everybody in this room believes in the free market, and the question is this.
Yes, sir.
I come from a very conservative family. I'm not crazy about Facebook, but one of the benefits of Facebook is that I can get on Facebook and see what my family is up to, and I truly enjoy that aspect of it.
Yes, sir.
If Facebook got to the point where my aunt, who posts stuff that I think is frankly insane, got kicked off of Facebook, I'd probably go somewhere else where I could actually interact with the people that I care about, many of whom I disagree with. So what's wrong with just not letting the free market do what the free market does so very well?
No, that's a great question. I have a certain worldview, and I don't really like regulating businesses very much. But in the instant case here, there's a major difference with the distinction. We're dealing with companies that have billions of subscribers, and they've reached what's called critical mass. So someone, there's certain hearings, and someone will say, why don't we go, if you Chris, you don't like it, go form your own Facebook or Twitter or YouTube. That's the kind of response back. But because they've reached critical mass, because they're so big, and because they've deliberately set out and successfully created a digital public square, you as a state legislature have the prerogative to hold them to higher standards of care, and that's what Representative Coleman's bill is asking you guys to do. And so...
And I can be sold on that piece of it, that they should be held to a higher standard than most other companies. I truly can be, and that's why I'm glad we're having this conversation.
Yes, sir, yeah.
But I do think that... so let me bounce around a little bit. You got this number set at 75 million. How many different platforms does that impact?
That's basically Facebook, Twitter, and YouTube. Even Parler has about 50 million, 55 million. It's hard to say exactly, but it's basically, in terms of actual reality, it's Facebook, Twitter, and YouTube, mainly. So,
and I'm going back to law school here, but
Yes,
is
sir.
it a bill of attainder that attacks specific people, or is that something that gets drawn after the fact? What's the bill? What's the rule of law where if you create a law just to attack a certain person or people, what's that called? Is that a bill
well,
of
I
attainder?
mean, in the instant case here, it doesn't specifically attack.
But
It
it's
doesn't
targeting,
name.
it's targeting
and-
3 people, though. We're
Well, I
passing
mean,
a law
not
that's gonna target
necessarily.
3 people.
I mean,
and
in
I'm
generally,
not saying you can't do it, but I know there's a term for it, and I can't remember from law school.
I don't know. To be honest with you, I mean, it's not really brought up that much. But in the instant case, it deals not only with Facebook, Twitter, and YouTube. I mean, I'm trying to provide examples to make it make
Sure,
sense.
but I'm just curious if we're going after Facebook, Twitter, and YouTube.
Well, they would qualify right now, but there can be new ones on the way up. For example, Parler. Okay, well, I don't know if they qualify, but there's definitely, if a new Facebook comes about, then they would be subject to this statute as well. Very easily probable that the new social media websites, in theory, could come up and they would be subject to it as well. So it doesn't target them deliberately in some weird way. But,
And then,
you know.
Okay, so and then this public square piece of it. Did you hear my question about the speed dating company?
I did, yeah.
I mean, I don't know if that still exists or not, but how would it be any different? You're still going into a public square,
Yeah.
and you're still going to be, saying something offensive or not. And I've got a pretty thick skin; it would be hard to offend me. But if you're in there being obnoxious and mean and rude, I think they ought to be able to kick you out. And I kind of look at this similarly, and I'd be curious to hear your response to that.
Yeah, well, again, so 75. You have to have 75, more than 75.
Sure, but I'm
million.
talking the concept. I'm
I
talking
got you.
the
I got you.
protection of free speech
I
and
understand.
protection of me to be me and you to
Well,
be you.
again, I mean, I'm a big proponent of the First Amendment. I'm a big proponent of censorship is a form of speech, if you will. And I'm a fan of being able to censor, but I'm not a fan of fraud. I'm not a fan of deceptive trade practice. And so with the dating situation versus a social media website, if how they market themselves is what you would look at. What do they do to induce people to come into the dating arena? If you will, what do they do if they said you can come here and act obnoxious and be yourself, blah blah blah? If they had certain standards, you have to look at what they were marketing themselves as. If that makes sense.
Yeah, I see where you're going.
I mean, not to pick on you, but it's a little bit of like an apples. It's kind of an analogy that's not really in the same arena, so to speak. I mean,
I only went to Mizzou Law School, but I very much disagree with you on that.
fair enough. Fair enough.
Then, so
It's a
going
good law
back,
school.
pardon?
That's a good law school.
Thank
Yeah,
you.
yes, sir.
Now going back down to this, getting into federal court, the $75,000 at a minimum, and it says a minimum of $75,000 in statutory damages. I mean, you guys obviously wrote that to get it in federal court.
Well, so here's one thing, by the way. There's a couple of things that are going to be amended. It got sent to amending. One is that part there is going to say the injured party that's been censored, Republican or Democrat, can seek up to $75,000. And then there's another section too, by the way, under the exemptions and exceptions that will be added that says if the speech constitutes copyright infringement or trademark infringement, that's an exemption. And we didn't have to do that, but we just were like, well, let's just make it further clear. And but you're right, that it is designed without apology to give litigants the option of litigating there if they would like to.
Okay, and that makes more sense than the way it's written
You're right.
at present.
Yes,
and the way I read that was this is just very intentionally designed to get this into federal court to get some case law on what's good and what's not good. And that's okay. I appreciate that effort, but I'm curious if that's what the effort is.
It's a choice of venue. I mean, I would say, we would respectfully say it's like the MasterCard commercial. It's like, how do you put a price on free speech? I mean, we'd say it's pretty priceless. And
I
so
agree.
they are really, really hurting a lot of people by censoring. So, the problem we have is you have here's a famous example, Franklin Graham. He'll get censored and he has millions of followers and he gets censored, right? And that's a famous case. Or you have these individual pastors, for example, who have their whole church congregation and they'll get censored. And their whole page will come down. And it's hard for them. They'll go to a lawyer and say, will you represent me in a breach of contract case against Facebook, Twitter, YouTube? And right now the lawyer should say no because you don't have these statutes. But you get these statutes, they should say yes. But
I'm always all for the new cause of actions. I've said that before. That
fair
part is
enough.
good.
Fair enough. I'm a lawyer that doesn't like lawyers, for the record, by the way. But in this case, this is a good use of lawyers, I would respectfully submit. But those pastors in that scenario, they can't really show actual damages, and so you want to have statutory damages because all you got to do is in a statutory damage situation just show that they're guilty of violating what the statute sets forth. And so all we're asking Facebook, Twitter, and YouTube to do, and those kind of websites, is just act in accordance with how they marketed themselves from its inception. Let us fight it out in the public square. That's all. Okay. Unless it's, of course, pornographic or violent, calls of violence or something, obviously not protected in any way.
So I want to make sure to leave time for everybody else. I've just got about 3 more questions. And one is, and Representative just mentioned the constitutional right to access to Facebook, but I'm not aware of any constitutional right to actually get on Facebook. Is there a case law that says you have a constitutional right to be on Facebook?
Well, so that's a good question. And the instant case here is the representative's quoting the court, I believe, and I'm going to take that at face value for the quote being accurate. And it doesn't surprise me because how they've reached critical mass. And to answer your question, there's no constitutional right that I know of to be on Facebook within the 4 corners of the Constitution. But I would say that it is the state can pass this bill and it not be unconstitutional because they're engaging in deceptive trade practice, false advertising, breach of contract. Those are unprotected forms of speech, if you will.
We've already got laws for all that stuff, right?
Well, not in the instant case, not like this. It deals with social media censorship. Respectfully speaking, if today teams like ours were to sue Facebook, Twitter, and YouTube under the Lanham Act for false advertising, it's a federal law. If we were to invoke Missouri's deceptive trade practices statute, consumer protection laws, I think we'd win, actually. But I don't think the courts want that. What the courts really want to see, and based on my observations, is that they really want specifically a state statute that is designed to fall within Section 230's state law exemption to accomplish this. Not to help Christian conservatives like myself, but so that we can really have robust debates on all sides. I mean, Senator Gabbard from Hawaii, that's Tulsi Gabbard's father, is the second guy to introduce the bill this session because his daughter was being censored to death by the social media websites because she was not woke enough or something like that, is what he would say. So anyway, I don't know if that's there. You go.
Yeah, so no, I appreciate that. And this actually leads into the last question that I do want to ask, and
Sure.
and this is where I think we ultimately disagree because I appreciate the First Amendment conversation. I largely agree with you, but here's the problem. One of my family members that I've previously discussed, she'll send me things on Facebook that are basically saying, the COVID vaccine is very dangerous to you. It's not a conversation. I mean, it's clearly protected by religious. Speech. You can believe vaccines are bad, and I think that's certainly a religious right. But she's sending bad information, stuff that is clearly false and frankly dangerous. And I think there is a place in this space for that to not be on social media, for information that's going to not directly hurt people, but ultimately hurt people and possibly hurt a lot of people. And I think there's a place for that to get yanked off of social media. The second part, and it's part of this, is that doxing question. There's nothing in this bill that stops the doxing that we literally were trying to prevent already this session. So that's my last question. I'd like to hear your answer, and I appreciate the conversation.
Yeah, absolutely. It's great questions. And I'm not really for or against things. I'm just here to testify of whether or not the bill is constitutional, whether it would work, just for the record. But to answer your question, I'm going to answer it by answering a question raised by Representative Engel. Because basically you're saying, what if someone's posting things about vaccines that might not be truthful? And what if that is injurious? Well, she was raising the question, what if the content is obscene or pornographic? How do we know what pornography is, for example, right? That's an issue. And we would say, she identified that you have the I know it when I see it standard, which is Justice Stewart from the Supreme Court created that, or you have the Miller standard. It's another famous Supreme Court case. The state of Missouri has obscenity codes right now. And so that defines obscenity, and ignorance of the law is no excuse. So that answers that question. We would say in court, based off of obscenity litigation, human trafficking litigation that we participate in. So I'm going to change the scenario, if you don't mind, to address her question, but I think it will answer yours at the same time.
I'd sure like to hear about the vaccines because I'm worried about
yes, sir.
that.
Okay. Well, let's say there was at the same time they posted a picture of President Biden's wife in a bikini, as well as a sign that says, we think vaccines are no good, at the same time, let's say. And they censored that. Well, first of all, if someone who posted that, sued them pursuant to this statute, then they invoke that defense saying, Your Honor, that's a call that's the violence, or it's dangerous, or it's injurious, so we censored it on that basis, predicated on this exception. And Your Honor, I'm sorry to pick on, well, President Biden's wife in a bikini, that's not obscene. And so, or that's, hold on, let me say, let's say she was naked. Let's say she was, and they deleted it. Well, the court would have to determine if the exemption could be successfully invoked or not. But we would respectfully submit that we don't think close calls are going to be litigated. I mean, it's a hard lift. And right now the bill says that the prevailing party can seek attorney's fees and costs. So that would ward off frivolous litigation. That cuts both ways. I'm not familiar with doxing. That's outside of the scope and line of what I'm used to practicing. But if you want to explain, I'd be glad to attempt to answer it.
I've taken my time. I'm good.
Yes,
Thank
sir.
you.
Okay.
All right. Seeing no further questions, Representative Pollitt, you're recognized for an inquiry.
Just to inquire quickly. Thank you this has been so informational for me.
Yes, sir.
The way you've explained stuff just seems to be down to earth in the way that I can understand it compared to a lot of folks that are attorneys. When they talk, I don't understand half what they're saying sometimes, so I appreciate you sharing this. My wife, who is further to the right than I am, she likes to go on social media and share things, and she likes the discussion because she's got a lot of friends on social media that are to the right and to the left, and she likes that conversation, and a lot of times that conversation is very civil, but it's interesting. Recently she shared some stuff from Ben Shapiro, and nothing came back to her, nothing. And so she got on the text, she started texting people, hey, did you get my share? And they said, we didn't get it. She contacted maybe 10 or 15 people that was in her friends list on her phone, and none of them got that. So obviously Facebook censored that, and why? And that's what I think the issue is. Stuff like that, who, is his views, are they considered to be offensive? And apparently somebody thought they were on Facebook because none of that got out and there was no conversation. And so that's what I think you're saying this bill is trying to protect.
Yeah, well, when they market themselves as being neutral, only to then to put a thumb on the scale and censor Ben Shapiro from the Daily Wire. I mean, shadow banning is a form of censorship. It's a form of bad faith. So we keep thinking about these in terms of deceptive trade practices, breach of contract, because we look at like how you market yourself, how you advertise yourself. It's a broken promise. That's not protected free speech. That's bad faith. That's consumer protection violation. So this bill is this is a progressive bill. That's what this is. All it is it's getting the existing law principles to catch up to modern day technology to solve a problem that's been ongoing. And really, it's great about we always say a lot in federal court. We think the state legislature should be the most powerful entity in the nation. And when we go to state legislatures, we're never talking to Democrats and Republicans. We're talking about the state legislature versus the federal Congress versus the federal court. And the bill, because it's written to fall within the state law exemption, it would cover things like bad faith, shadow banning, and things of that nature. We want those practices to stop. That's not fair. It's unfair. I mean, there's lots of representatives and senators we know that are Democrats and Republicans who pay a lot in campaign, like to promote their Facebook and Twitter when they're running for office, and they've noticed they got 5 likes on that and 5,000 on something they didn't pay for that was neutral. That's a form of unjust enrichment and bad faith. They can't do that, and it's injurious to all of us. So I hope I answered your question.
And again, I just really appreciate you being here and spending time with us.
Yeah, thank you for having me so much. I'm a soldier first before I'm a lawyer. So, for the record.
Further questions? Representative Engel, you're recognized.
Thank you, Mr. Chair. Gentlemen, earlier you stated that Democrats sponsored this bill in several other states. What states were those?
Rhode Island. It's Vella Wilkinson.
Okay, so just the one state?
No, I was going to name them.
Oh, okay.
Senator Gabbard.
The states is fine.
Senator Gabbard from Hawaii. Senator Sanders from New York, and there's 29 states moving on this. There's a long list. Now, my colleague, Sergeant Major Gunter, he keeps track of who's prime sponsoring.
And are you a lobbyist?
No.
Okay. Did you write this bill?
No.
Okay. Well, you said your partner.
Well, we have many lawyers. We would respectfully submit that the bills are written out of multi-state federal litigation, so it would be different suggestions from judges and courts that. It'd be language that's pulled from different pleadings and opinions, if you will. So there's many people that we support this bill. Representative Coleman is the author of this bill.
Okay.
We support his bill.
Okay, thank you.
Yes, ma'am.
Thank you, Mr. Chairman, for these hearings. I'm Cameron Schulte from the Heartland Institute. I submitted written testimony earlier today, so I won't go over that. It's getting late. But there were a few things I did want to touch on. In particular, some things that were said. The one thing I want to impress upon you is you have responsibility as legislators for the residents of Missouri. And because an issue is complicated is not justification for not doing something on behalf of Show Me Staters. I'm from Wisconsin. I have this nasally, horrible Fargo-like accent that you only hear in the movies back down here. You guys are so much more charming than mine is. And I would not want my state representative to do anything that wasn't in my best interest. And your best interest is Missourians. Because it's complicated, because Google says it's complicated, is not sufficient reason to not tackle an issue where real, legitimate frustrations of social media users are apparent. You are politicians, and you know full well that perception is reality. And if Missourians feel that they are being maltreated on the internet, then they are being maltreated on the internet, regardless of how complicated Google or NetChoice or Facebook or Twitter says they are. These big tech companies have a vested interest in the status quo. It's a golden goose. It really is. The democratization of the internet meant that Representative Rogers can talk to his aunt and see her crazy postings online. It means my brother can send me ridiculous memes that I have zero interest in, but I have to laugh at the family reunion and say they're funny. So that democratization has given way to where we are today, and we're having this complicated debate. Not to single you out, Representative Rogers, just real quick point I wanted to make. You had asked about why a restaurant or a speed dating facility. Do they have speed dating facilities? Is that a thing? But I think the point there is, what is the difference between a restaurant not being able to kick somebody out and why Twitter can censor? Those speed dating facilities or a restaurant does not have a special carve-out in federal law under Section 230 that provides them with all manner of immunity from liability. Those are special protections carved out for them for that very reason. Their actions, big tech's actions, then almost can invite the regulation, and I don't want to, I'm not an attorney and I don't want to go too far into the tall grass on this, but that type, the behavior almost invites the regulation of state lawmakers under Section 230. I won't go any further. If anybody has any questions, I'm happy to do the best I can. Again, it's more of a 30,000-foot level view of the issues I'm happy to provide.
Thank you for that testimony. Do you view House Bill 482 as a regulatory bill on contracts, or do you view it as a fine structure? Like what is your view of the bill in its nature?
I would be deferential to the bill author and the folks that he worked with it. I had no role in drafting that legislation. Now, having said that, though, in my written testimony, I point out, and I know this is a generic statement, but I think it captures where I'm at and where the Heartland Institute is at on the three bills as a whole are good first step bills, which should also spur a state-based and national debate on the role of big tech in our civic conversations. They are perhaps the tool policymakers need to give to Missourians, such that the message is clear that robust public debate is sacrosanct, and any action or failure to act to ensure robust debate will be met with hard questions and, if necessary, enabling policies.
What is your response to the line of argumentation that these are private businesses and they should be able to control what exists on their private platforms?
My testimony started as 2 pages. It has now grown to like 15 because of all the notes I've been taking and some additional thoughts here. The big tech operates in what is effectively a government-sanctioned market. It exploits that government-sanctioned market to its advantage, opposes free market reforms, and therefore is not entitled to state government political free speech protections.
What do you think makes it a government-sanctioned market in this context? Is it Section 230? Is it something else?
Section 230. Because if you look at Section 230, there's some very specific things that they can and cannot, or rather, that is permissible, and it specifically forbids. And basically, Section 230 gives big tech these parameters, these guidelines, that they're allowed under their Good Samaritan clause. Anything that is obscene, which clearly in the bills we're discussing does not apply, because we're talking political censorship. Lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. And that's where the crux of it is, because anything that is deemed otherwise objectionable then becomes that catch-all for censoring a person or an idea.
All right, thank you.